Hello, good afternoon, and welcome to The Law. This is your Legal Light and Help Law. Today, we continue part 2 of the topic we had with you, landlord, tenant, and rent control, 2 weeks ago. Because you have insisted that you need a part 2 to have your education complete, we recognize that that is important. So today, we'll do a quick recap of what we did the last time and then bring you up to speed on your rights and the landlord's rights when the landlord wants to recover possession, wants to take the property back from you or want to eject you from the premises. Don't go anywhere. We have the best to do this discussion with you. Be right back.
When it comes to landlord, most of the problem they bring to us is rent arrest. Just if you have to quote from 2019 statistics, about 72% of the cases that came were on rent arrest, which means a lot of tenants are not being able to pay their rent. So that was very massive. And then again, when it comes to tenants, the issue has to do with inducing them to quit and also claiming their refund of rent advance, which means they've paid advance and now, due to some circumstances, they have to move out from their premises. And now they are now chasing their advance and it's not coming, so they refer those things to us. So these are the two major, or if you like, three major issues that come to the rent control department.
So presently, the law doesn't say I can't give my property or my apartment for rent for more than 6 months. That's not what it says.
No.
Please explain.
Okay. So when it comes to short tenancy, you can sign an agreement with somebody that I'll be taking monthly rent advance from you. If you sign that agreement and then you go sideways and then now you say, no, I've taken 2 months already. Next time I'm coming to take 2 months, or I've taken monthly for the first 3 months.
Okay.
Now I'm coming to take 2 months. This constitutes an offense if it comes to the short tenancy.
Okay.
When it comes to the long tenancy, the law or the act is stating that for long tenancy exceeding 6 months, which means you can sign an agreement with somebody for 1 year, 2 years, 3 years and above.
Right.
But when it comes to the payment, you are not supposed to demand or even collect. The law says don't demand and collect. So if you sign 5 years tenancy agreement and you come and demand 7 months rent advance from that tenant or prospective tenant, as we call them, you commit an offense.
Right. So we continue, and in due course we'll open the lines for you to join us with your questions as always. And we have the gentleman who has all the answers to your questions for you, Emmanuel Hove Posu. He is the Public Relations Officer of the Rent Control Department of Ghana. Thank you so very much for making the time once again.
Thank you, Samson. And then let me just express our appreciation again on behalf of the ministers, on behalf of my Chief Rent Control Officer, for the management of the company, the producers of this company. And to you, Samson, no wonder you are still the reigning journalist of the year for the good work you are doing. We are so appreciative of your work.
You are so welcome. Yeah. And I must say that we owe you a debt of gratitude because you make the time to make yourself available and to give the public the education that they need. And more importantly, this education that empowers them, both the landlord and the tenants. And so as you have discovered, we are not doing a one-way thing. Too often the discussion is landlord, landlord, landlord. It's not correct. It's not true that all landlords are bad. There are tenants who are terrible. and we know about that as well. So you just get ready. Today we are continuing and asking, when can you be asked to leave the premises? When can you be ejected? What are the conditions that will warrant you being removed from the landlord's premises? Right. So we ended on that note where, in the recap, you spoke about the fact that you cannot demand or collect rent advance for more than 6 months for a rental that is on a yearly basis. Exactly. Right. And there is a consequence for that.
Exactly.
So remind everybody again, because sometimes all of this is important.
Okay.
Now, yeah, go ahead.
Yeah, so under Section 25(5) of the Rent Act, that's Rent Act 1963, Act 220. If you look at Section 25, subsection 5, and it reads, any person who has a condition of grant, renewal or continuance of a tenancy demand in the case of a short or monthly tenancy, the payment in advance or more than month's rent, or in the case of tenancy exceeding 6 months, the payment in advance of more than 6 months' rent, shall be guilty of an offense, and upon conviction be liable to a fine not exceeding 500 penalty units, which is equivalent to 6,000 cedis, or a term of imprisonment not exceeding 2 years. And based on the discretion of the magistrate, these two can be combined. So you can get the fine as well as the imprisonment. And that will be based on the discretion of the magistrate, actually.
Thank you very much. So you take note of that. Now, we need also to go back to the question of the importance of how we should enter into the landlord-tenant relationship.
Okay.
We have emphasized that preferably the law requires that you should enter it in writing.
Yes.
So that you have a document known as a tenancy. You all agree to the terms. But there's the situation where you can also do it without it.
Yeah.
And how are you protected in both cases?
Okay. So, again, under the PNDC law, we have under Section 4, that is the PNDC law 138, that is Rent Control Law 1986. Under Section 4, the topic there is landlord to register lease and tenancies. And subsection 1 reads, every landlord of any residential accommodation referred to in this Section 1 of this law shall register with the Rent Control Department every lease or tenancy agreement in respect of such accommodation within 14 days of entering into the lease or tenancy. Then subsection 2 says, no landlord shall demand or receive from the tenant of any residential accommodation the rent in respect of such accommodation without complying with the provision of this subsection 1 of this section.
Right.
So which means when you get a prospective tenant to come and occupy your premises, the first thing you have to give the person is the tenancy agreement for the person to look through and make sure all the provisions you've laid down there, you will abide by them. Of course, you have to take into consideration the Universal Declaration of Human Rights. You have to take into consideration our Constitution under Section 12(2), where it talks about our human rights and freedom. You have to take into consideration some of the provisions we have in the Rent Act, so that you will not be infringing on somebody's human right. That's the main reason why you have to register this tenancy agreement with the Rent Control Department, for us to go through and make sure you are not going to infringe on somebody's right. So this, if you've not done this, the law demands that you don't have the right to demand any rent advance from anybody.
Right. So first thing, and for emphasis once again, the landlords, you are expected and required by law, you have an obligation to register the tenancy agreement. That is the contract you enter into with the tenant. Within 14 days, you register it with the rent control. They will keep a copy, and it's for a good reason. If you don't do that, you are breaking the law. You need to do, is it not the assessment that comes first?
Yes.
To determine the rent?
Exactly.
Okay, explain that.
Yes. So if you build your premises and you want to dwell in or occupy or give it to your daughter or your son, the only institution you have problem with is the assemblies where you pay your property rate. When it comes to mind that I want to get money out of these premises, I want to commercialize these premises, the first point of call is the Rent Control Department. From Section 10 up to Section 19 of the Rent Act talks about what we call an assessment. The assessment is where we'll come to your premises, look and see whether the place is tenantable. Look at the materials you've used, look at the location, look at the facilities you've used. And this will aid us to come out with a rent or a rate you have to charge your premises. And we do this assessment every 2 years. After we finish the assessment, we give you what we call an assessment certificate, within which we state how much you have to charge. So this is more like a leeway or a guarantee for you for now to advertise for your premises. So
you don't go about advertising the premises for rent until and unless the assessment has been done.
Exactly.
And the rent is determined.
Exactly. This is what
then when the potential tenant comes in, you take the tenancy agreement, give it to them, you all look at it nicely. Once both parties agree, within 14 days, you go and register the tenancy agreement. Good. Now, in doing the assessment, if you went about, are you arbitrary in coming to the conclusion as to how much, you know, the landlord should charge? Some people feel, I can't use my money to build my premises, and you come and determine how much I should charge. You said you go there to check if the place is tenantable, meaning it is a place that in fact can be habited by human beings. They can live in.
Exactly.
So do you do that arbitrarily? And if I don't agree with you, the amount you say I should be charging, what happens?
Okay. So just as I said, from Section 10 to Section 19 talks about this assessment. In a case where a rent control officer comes to do the assessment and you don't agree, the next point as the Act stipulates that is that you just move straight to the magistrate.
Rent magistrate.
You appeal. You appeal to the magistrate. The magistrate will look at our recommendation or what we did to come out with the rate. In the opinion of the magistrate, we will then refer the case back to the Rent Control Department for reassessment, or in the minds of the magistrate will conduct his or her own assessment. So in the case, just as you asked, when you don't agree with the assessment, the rate, the point is that you move to the magistrate, you appeal.
Right.
And that appeal, we have a process, we have to give all the necessary information to the magistrate. So you still come back to us, we draft all those things, we give it to you, and then you go to the magistrate for...
So there's clearly an opportunity if you disagree with the amount or the assessment, then there will be a third party neutral to get involved so that settles it between you and the rent control as to the amount of money you can charge as rent. Then you proceed to the next step, that is advertise. If you advertise without the assessment, you are breaking the law. Then when you advertise and a potential tenant comes in, you decide, the two of you, it's a contract between you, a tenancy agreement. Once you sign that, you seal it, you now give a copy to the rent magistrate, rent control department. You register it. If it is not such that they are signing an agreement, as in rent agreement, what is the procedure? Rent card. Okay.
So the tenancy agreement is a must.
Right.
It's a must, which has been clearly stated in the Act.
Okay.
And what we are saying is we have a sample in our offices, as well as you can contact any lawyer to assist you in doing that. So that is one. The second thing is that within 7 days after you sign the tenancy agreement, you are to issue the tenant with what we call the rent card.
Okay.
And this is the rent card, which comes in twos.
Right.
Okay. So any information here is exactly what is here.
So we showed you a copy of this the last time. Okay. So focus it here.
Yes.
Right.
So you have details of the landlord, you have details of the tenant, and then there is an emergency or a guarantee number, of which if something happens to the tenant, you, the landlord, can fall on for an assistance or any help. Also, when you look in there, you see the monthly entry of the rent that the tenants pay, so that in future there will be no dispute. I have a exact copy, you also have a exact copy.
Right.
I cannot pay 6 months, then you come that I've paid 4 months. No, the paper will talk for itself. So this is the rent card.
Right.
And then we also have a receipt. And if I give you 1 CD, the law demands that instantly you have to give me receipt. So that landlords must take note. And then we have what we call the rent tax. Every rent that you collect in this country, there is a tax that has been, you have to pay for. If it's a commercial dwelling, you pay 15%. If it's a domestic dwelling, you pay 8%. And this can be found in the Income Tax Act, that's 2015, under Section 115. So you pay your tax on the rent that you collect in the country as a landlord.
So the last time I mentioned something to you, that the rent card, why it is useful also to you as a landlord and also to the tenant, is that it provides, a whole year-round table. From January to December, you have that for covering 4 years. So you don't end up forgetting anything. If rent is paid for a particular month, you take that it's been paid, or you sign, you write it there, and then the signatures are signed against it appropriately, so you never forget. And then sometime there may be some fight. But as he said, you issue the receipts accordingly so that there's no any issue. You must take your duty as a landlord very seriously and not make it too casual. Take it as a business, a pure business. Then you make sure all the documentation required, you are following the law in that respect. We will be opening the phone line soon. But now let's go to the thorny question, the vexed matter of when can my landlord ask me to leave? When may I be ejected from the premises? What are some of the things that could happen? We gave you just a bit of that last week. We are continuing this one as well. All right, so please, Emmanuel, let's go on. Yeah.
So when it comes to recovery of possession or ejection, under the Rent Act 1963, Act 220, we'll look at 5 sections which talks about this ejection. The first one we'll talk about is under Section 23, and it reads, no landlord or landlady of any premises shall serve notice to quit on a tenant of such premises within 2 years from the date of any assessment, order or decision of a rent officer from which there has been no appeal, or of the rent magistrate, or of any other judge or court of competent jurisdiction, unless the lease is due to expire within the set period of 2 years.
Yes.
So what this basically means is, if you sign a tenancy agreement with a person for 1 year or 2 years, you cannot just come and serve quit notice at the first month. If there is no provision in the tenancy agreement that will meet when it's getting to 3 months to the expiration of the tenancy agreement, then you, the landlord, can serve the notice that at the end of your tenancy, I will not renew it again, I will be taking possession. But you cannot say, we've started 1 year tenancy agreement, by the 6 months I want to recover my possession. The law does not allow you to do that.
All right.
Your notice should end at the expiration of the tenancy.
All right.
Then we look at Section 17 of the Act. The first point is that you as a tenant should not be indebted to the landlord of a month's rent.
Yeah.
So if you owe any landlord a month's rent, the landlord can just stand on this, come to the rent control department, and then apply for what we call order of eviction. But the landlord has no right to forcefully eject the tenant because the tenant is owing him or her a month's rent.
All right.
The second one, under Section 17, is when you break any obligation of the tenancy. We signed a tenancy agreement. Now the provision that we've all agreed that will follow, now you are breaking them. Also, the landlord has to come to the rent control and apply for the order of eviction. The third one is being guilty of conduct which is of nuisance or annoyance. Example is we share facility like water and electricity. You alone, the bills has come, we've all agreed that we will share it this time. We've shared it and then you stand up and say, I will not pay. You are causing nuisance. Because of you, the other people will be suffering. Or you alone, midnight, you just like music around midnight where people are resting for them to go work the following day.
Oh, you are not keeping yourself clean.
Exactly.
There is a lot of dirt. You are keeping things that go bad and it's smelly all over the place. Everybody is stalking you. You won't listen to anybody. Well, you must live in your own apartment, in your own house, or you cannot live with other people. As simple as that, right?
Yes. So, of course, again, if you are going through such conduct, the landlord or even the co-tenants can come to the rent control department and apply for the order of eviction. I'm stressing on the order of eviction.
Exactly.
Because most landlords, in their mind, if an offense is committed, they just take your belongings and then throw them away, raise guns on you. All this, the Act has provided that you apply for the order of eviction for us to do a due diligence, do investigation, and make sure the complaint or the allegations you are putting on the tenant are correct, and then we'll order the tenant out of your premises.
Right.
Then we'll move the fourth one, be convicted of using the premises for immoral and illegal purposes. I mentioned here that even the rent control officer cannot determine what immoral and illegal purpose is. Not so with the landlord. So when something happens, report to us, we'll follow the due process and lay your complaint before the magistrate.
Yes. So,
for the magistrate to determine what illegal.
For example,
yes,
possessing, cultivating, sniffing, administering, smoking, inhaling, in whatever form of marijuana is prohibited in Ghana without license. If you come for my premises for the purpose of a business or even for the purpose of residential purposes, and then I find that this is the business you are conducting in my premises, you are using it for an illegal purpose. The point, however, is that I am not a law enforcement agent. So I go to rent control and inform them that this is what you are doing. Then they will ensure that you are ejected. If you came in and you said you needed the premises for whatever it is, like we heard recently, and then we discovered that you are using it for gay, lesbian activity, you make a report. They will go and take care of it where it is appropriate.
Okay. So the next point is allowing a condition of a premises to deteriorate. You come to take my property, you don't take care of it. When it comes to maintenance, the landlord has his own maintenance to do, the tenant has to do. All this has to reflect in the tenancy agreement. If it doesn't, then in general terms, the external maintenance is the duty of the landlord, and the interior is the duty of the tenant. But we don't want a situation where the landlord will be frequently coming into your room to inspect. So you schedule all these things so that everybody will know what is expected to do. The next is when you, as a tenant, give a written notice to quit.
Right.
So your time is getting up. You've written to the landlord that at the end of my tenancy, I will quit. Then when your tenancy expires, now you come begging. It's not right. The landlord has the right, because based on your written notice, he has also started contracting somebody, or even contracted and even taking an advance from somebody. So you not moving out, the repercussion, probably the person who is moving from somebody to come and occupy your place also has given notice to the landlord, and then the reaping complication will be too much. So in this case, you will be forced to move out.
So as you see, we discussed the other time, because the tenancy is in writing, you always will see that the two of you have agreed that 2 months to the expiration of the tenancy, or what in law we call determination of the tenancy, 1 month before, 3 months before, it's between the two of you who agree what period you must give a notice to say that you want to renew or you are not interested in renewing. And that's what he's referring to. So if you're entering into the tenancy, it is good to agree with your landlord that it's sufficient time. That serves all of you well. Right.
Okay.
Yeah.
Then the next point is, there may be circumstances that a landlord may have traveled, and then based on some circumstances, he has to come and occupy the premises. Of course, that's his or a premise. So the law gives the landlord that's right. But in that case, you give the tenant some ample time to look for an alternative. So at this point, you give the notice, and then the tenant has to prepare. Of course, if there are some advances that has to be refunded, we negotiate and tell the tenant when that money will be paid.
So you are the landlord.
Yes.
You are traveling. You don't want your premises to be idle.
Exactly.
So you are giving it out for rent. And then you are coming back.
Exactly.
Look, it's reasonable. That's my place. I built it for myself. Or even, you know, the landlord's relations, family, child, or something like that. Okay.
And again, if it's a business premises, we follow the same process. That I was doing the business and something took me out of the place. I gave it to you for some period of time. Now I've settled those cases and I want to come back. I will give you notice. Though the tenancy has not expired, the law gives that right to the landlord to give you notice to look for an alternative. And then again, upon expiration of tenancy and the premises needs to be redeveloped, remodeled, or pulled down for a new one to be constructed. So of course, if the place is deteriorating, the landlord has the right to give you notice so that it will not cause any mess for you to move out, so that you can do the renovation, do the remodel, pull it down and construct new one. But there's a provision in this act that when you are a tenant and you are occupying, and under such circumstance you are evicted, you should be the first person to be considered when the remodeling or the development is over.
Okay, so let's quickly run through the few that's left, and then we'll take your calls, we'll take your messages and questions and answer them as well. Let's quickly run through the rest of them.
Okay, so the next one is, if I'm a landlord and I've employed you as a worker, and now your employment has expired. Of course, you don't need to stay with me any longer. I have to get you out, and then the new person I'm recruiting can occupy. And then reoccupy after letting the premises during landlord absence, which we've talked about. And then we move to section 22, which is on the topic subletting. So you can sublet. If you sublet without the written consent of the landlord, the landlord has the right to evict you. If you sublet,
so someone else wants the property or the premises. You are occupying, say, a room. And you want to give it out, or it's a whole house. And you want to give it out. Because you are not the owner, because you are not the landlord. You need the permission of the landlord before you give it to somebody else and take money. That is what is meant by subletting.
And it has to be a written consent from the landlord. And then also, when you are subletting, you should not sublet which will exceed your period of tenancy. If you do that, the landlord can stand. And then refuse to inform the landlord in writing of the fact about the person you've sublet the premises to within 14 days after the subletting. So that is, and then under section 25, when you demand or receive any condition or grant, renewal or continuancy of an assignment of a tenancy. So, just a simple example, you occupy my premises and then you take any condition of grant. The landlord can just use this and report you, or demand or receive a price or condition for purchasing or hiring. Okay, it's similar to what I just, and then entry into or carry out any fictitious or artificial agreement. So when the agreement is given to you, and then you give just false information, okay, and later is discovered, the landlord can just stand on this and then
basically the property is not yours.
Yes.
You have no business trying to engage into a transaction in connection with that property with another person without the written consent of the one who owns the property. In law, we say, nemo dat quod non habet. What you don't have, you can't give. I don't understand why some people behave that way. It's not your property, and you are entering into some agreement with somebody to take money and to give the property to them. Is it yours? Or to even rent it? It's not yours. Okay.
Yes. So in summary, under section 28, talks about basically about the subletting.
Right.
You can just give the possession to somebody else without informing the landlord.
Okay.
So these are things that tenants should not do. Because if you do any of this, the landlord can just stand on it, come to our office, apply for the order of eviction, and then we'll investigate, and then where the law applies, as I always say, we apply it.
Right.
Yes.
So thank you so very much, Emmanuel Hove Posu. As you have heard him, he's the Public Relations Officer of the Rent Control Department. And there are some of you who have been asking me, is he a lawyer? Well, what is important is that he has studied his law as far as this area is concerned. Now, we are going to give you the opportunity to join us and let us know what is happening as far as your rent is concerned. What are the questions that you have in this regard? When I return, I have a question. We have treated it here before when the coverage started about a statutory tenant. People have heard about it, that I am a tenant, I owe, but the landlord cannot take me out. What exactly is it? Who do we have? Kobna, you are calling from Tema. Thank you for joining us. What's your question?
Afternoon, Samson.
Welcome.
Yes, I rented a place. I'm staying in the house, and then it seems that the landlord increased the rent every year. We pay the rent every year. So at the end of every year, you have to increase the rent. That's my problem now.
You say that where you are renting, the landlord increases the rent every year.
Every year, yeah.
What is your rent agreement with the landlord like? For how many years are you renting?
No, there is no agreement at the moment.
How?
I got it through a friend.
Okay.
Yes, and that is how I came to live here.
Did you pay an advance deposit?
Yes, I paid an advance of 1 year.
Of 1 year?
Yes.
Okay, so after the 1 year, your landlord has increased the rent?
Yes.
Okay,
and
that's what...
it's not only me, those living in the house.
So your landlord gives you for 1 year, and after 1 year, your landlord will increase the rent and expect you to pay to continue.
Yeah.
All right. Thank you very much. That is noted, Kwabna. Afum, you're calling us right here in Accra. Hello, Afum. Okay, too bad. We just lost Afum. But let's attend to Kwabna's situation. Okay. There are some landlords, that's just how they do it, right?
Okay. Yeah, so under section 19 of the Act, it says landlord prohibited from collecting rent increase resulting from increase in rate without notice. So as a landlord, you cannot just because, just a short scenario, somebody just told me that the Lekma Road, because they've done the road, the landlord is increasing rent. You cannot do that. First,
because when the road was not done, there was a lot of dust that was going into. So the place was unattractive.
Exactly.
And they were giving it for chiefs.
Okay.
Now the road has been done.
Okay.
Thanks to government. So now they can take more.
No, but it's not your money that was used in constructing the road, though you pay your tax. So what you have to do, come to the rent control. Let's come and do reassessment.
Okay.
You have the right to come anytime if an improvement has been done. Of course, the facility around,
so
come and do the reassessment.
Kwabena and his friends in the house can make a complaint to the rent control office.
Yes.
Right.
Yes.
The principle here is that the law requires that you cannot increase rent without reference to the rent control department. Yes. Thank you. It's a phone back. Okay, Inusa. Hello, Inusa. You are calling us from Konongo. What's your question? Hello, Inusa.
Yes, sir.
Yes, go ahead with your question. Speak up. Too bad. Hello, Albert. Let's hear you. Hello, Albert. I can hear you say afternoon, but it's so low. I can't hear anything. Hello, Albert. Okay, maybe we should get on to our guys, the guys joining us via Zoom. Okay, hello, Inusa. Oh, what's happening to the lines? Your lines are just dropping. I don't know what's going on, but keep trying. Keep trying. We have quite a number of you joining us via Zoom. Okay, so we can go to Zoom now, right? Okay, all the guys on Zoom, if you are ready to ask a question, please indicate that you are ready to ask a question and not that you are just joining to listen. Hello, John. Hello, John.
Hello, Samson.
Yes.
Good afternoon.
Good afternoon. You are calling us from Axim?
Yes, please.
All right, what's your question?
Thanks for the opportunity. I rented a place. I paid 2 years in advance. The landlord, after collecting the money, decided not to complete the house was uncompleted. It was left with some finishing touches. After collecting the money, decided not to complete it, and then later was making troubles with me, so I have to find a place and rent. I was in school back then, and then the landlord was having troubles with me every day. So what is the law on this place?
Okay, thank you, John. Your question has been noted. Alhaji Kamal, you are calling us from Tamale.
Good afternoon.
Good afternoon, Kamal.
Yeah. Mr. Sampson, my question is, I want to know if somebody rented your premises and you give him tenancy agreement, and it gets to a time the person needs an extension to the place, then you start with him and talk. If I'm doing the extension for you, this is the amount you are going to add to what you have been paying. So you all come to agreement. Maybe you ask the person to pay 500. And after the completion, the person is telling you that he's going to pay 200. Then you say, no, the person sent you to rent control. From there, you went and narrated the whole issue. The person was not sort of satisfied, and then take you to court. You've been to court for 5 good times. The second time, the person is no more coming to the court. So when we went to the court about 5 times, the magistrate said, if this person bring you to court, and you get to the time the person is no more coming now, then the judgment is, I have set you free, go. And the time has expired. If you want the person to leave your premises, are you going to rent control, or you are also going back to court to make your complaint.
Thank you, but I would think that the reason you went to court was over the matter, and so the rent magistrate would have made the appropriate orders in that regard. But you know, Emmanuel will help you here. Let me take a final one so that we get the answers to the questions before we take another round of questions. Nana Kakraba Yanka, you're calling from Obuasi. Let's hear you, Nana. Hello, Nana Kakraba.
Hello, Samson.
Yes, go ahead.
Yeah, thanks for the opportunity. Yeah, Samson, thanks for the opportunity.
Go ahead.
Yeah. I am a landlord at Obuasi, but my premises is in Takwa. A tenant has lived there without paying rent for the past 5 years. Now, I reported the matter to the rent control. Rent control took the matter up and then raised it to the police. And the time went to the tenant, having called the tenant for some time concurrent. The rent control moved to the premises and moved the tenant's property out of the room and locked the rooms. After some few days, the tenant broke the premise, the rooms in which the rent control has locked them, and then lived in the room to today.
I see.
Now I'm asking, the rent officer told me to take the matter to the court. Now, who pays the cost of the whatever I'm going
thank
to
you,
incur at the
Nana
court?
Kakraba Yanka. Thank you very much. And when we give you the opportunity, please be very snappy with your questions so we can take more and answer them. Okay, so let's start with Nana Kakraba, and I'll answer the last part of your question. Once the rent control had finished their job by ensuring that your tenant was evicted or ejected from the premises, if your tenant came back and did what he did, he was committing trespass. He was committing damage to property by breaking your property as well. These are criminal, and that's why the rent control officer asks you to bring in the police. The police must be taking the right actions and ensuring that this person is prosecuted and thrown behind bars. Yes.
Yes. So that answers the last question. The issue about the extension, what we are saying is that you all have to agree on paper. If the place is not conducive and you, the tenant, want to improve the place, it has to be on paper. You all have to agree as to the payment terms or as to the extensions. So the issue about, is it Karim or what you are saying, you have to be on, it must be written to us to be clear for anybody, as well as John. Okay, John also asked of the improvement issue, and then Karim on extension. The extension issue, if the court makes a decision, we, the rent control, cannot override that. So the court has to determine what has to be done next. So you have to go back to the court, and then you reopen your case for it to be determined. But let me sound this caution or advice to every tenant, every landlord, and all the citizens. Under Regulation 38 of the Rent Regulation 1964, it states, subsection 1, or I'll just move to subsection 4. It says, every person summoned to appear before the appropriate rent officer or rent magistrate shall appear before such officer or magistrate at the date, time, and place specified in the summons. Subsection 5 says, any person who contravenes the provision of subsection 4 shall be guilty of an offense and shall be liable upon conviction by an appropriate rent magistrate to a fine not exceeding 100 penalty units or to imprisonment for a term not exceeding 6 months or both such fine and imprisonment. We've been hearing, or we've now be consulting the police, which we have the powers here, that when a summons is given to you and you refuse to appear, we can just line you up before the magistrate and prosecute you before the magistrate.
Yeah, that's according to law.
Exactly. So landlords should take note, tenants should take note, and anybody interested in any premises should take note of this regulation.
See, we live in a country of rule of law. Without the law, it will be, you know, a jungle, and anybody will do whatever they want. So the law is to protect both of us, not just the landlord against the tenant, but also the tenant when the landlord is doing the wrong thing. So if the rent control invites you because you have been summoned, you should attend. If you don't attend, you are committing a criminal offense. Police will pick you up, and then you'll be thrown into prison for that. I think we haven't responded to the very first question by Kobna. Kobna is the one that their rent is increased every month.
Yes. With that, I quoted Section 19 of the Act,
right,
that no landlord has the right
to increase so
without
they should make a report, they should make a complaint.
Exactly.
Okay. Thank you very much. Now, I'll take one caller from the phone lines, and then I'll get to those of you who are on Zoom. Hello, Constance. You are calling from Tetegu. Hello?
My question is, I rented this office space. I rented for 3 years. And then this is my...
Your line is bad. Your line is bad. Can you start again?
Please, I've rented this office space for 3 years. And then I keep renewing it. This is my 3rd year. And then all of a sudden, I saw that the task is coming out. And so I reported it to the landlord. And then he is saying, I have to do it because it's not my fault. And to me too, I think it's not also my fault. It is coming out. So my question is it me who's supposed to do it, fix that problem, or is the landlord?
All right. Thank you very much, Constance, for your question. Let me go to Zoom. Hello, Samuel. Yeah, Samuel, go ahead with your question. Unmute.
I rented a chamber and hall with a porch, and the porch was not covered. And I asked the landlord that I want to cover it so that he can extend my rent period for me. And also I laid a tile. She agreed. But later when my rent expired, he declined that I did that.
I see. That's bad. We'll deal with that. Dominic. Hello, Dominic. Quick.
Hello, Samuel. Yes, my questions are threefold. One.
You ask one. Ask the most important question. We don't have time.
Oh, okay. So I want to know, it looks as if in Accra it's very difficult to rent properties. I know they look at the prestige nature of the area and price the property. So I want to know, do we have any law that will protect the tenants as whether when we are going to rent, we look at the size of the rooms, the nature of the place before we pay for the place.
Thank you very much. Let's get you some answers. Thank you. Let's get you some answers, and starting with him.
Okay.
Right.
So the law is that we have to do an assessment, demand the assessment certificate that will tell you exactly how much you should pay for that property.
Rent control has done the assessment of the property, and they have fixed the rent. That's one of the things we discussed earlier.
Okay. And then with Samuel, we are saying all agreements must be written. It shouldn't be verbal, just as we say. Now you've done the work. The landlord is demanding. There's no proof. There's no evidence.
So you should have put it in writing that you were going to do the work, and that the amount you spend will be converted into rent, additional rent. It would have been easy. Okay, so please take note. Next time, don't do it just verbally and leave it there.
Okay,
right.
So these are the
Constance. Constance is being asked to fix the tiles.
Yes. When it comes to maintenance, just as I said, the external maintenance is for the landlord, the interior is for the... But there are issues with wear and tear. If the person has lived there for a very long time and the place is deteriorating, you don't expect the tenant to do. It's your responsibility as the landlord. Because just as I mentioned, so far as the place is being used frequently, there will be wear and tear. And it's your responsibility as the landlord to fix that premises.
After all, you landlords will always say, we are increasing the rent because of what? So you must do something and then go to rent control and do the reassessment and say, I have made this expenditure on the property. They will add it to the rent and then your tenants will pay.
Exactly.
If we all obey the law, we will live happily in this country. I think I can take one more from Zoom. Hello, Jonathan. Jonathan, unmute and ask your question quickly.
Yes, hello.
Go ahead, Jonathan.
Thank you very much for the opportunity. I rented recently, and there's a problem with water. There's a backlog of bill up to 4,000 Ghana cedis before I started using the place. So what is the advice, please? Thank you.
Did you hear exactly what he said?
So did you? The bill was there before you rented the place. Is that your question?
Yes, please.
Okay.
You didn't contribute to the bill?
No, please. No, please.
Okay, thank you. That's clear.
Yes, so quickly, the landlord should fix should go and pay it. Then, from the time you enter the place is where you are supposed to pay the or any utility that.
All right. So what this landlord is simply supposed to do is that if he's making extra expenses and so on about all these things, go do a reassessment nicely so that you can get rent that will compensate whatever you are spending on the property. Remember, you cannot do it unilaterally, and you need the permission of the rent control to be able to do that. We have just about a minute, but I asked a question about a statutory tenant. Who are they and what are their rights?
Okay.
Right.
So when you look at the description or the interpretation of it's a statutory tenant means a tenant who remains in possession of a premises after the determination by any means of his tenancy and cannot, by reason of the provision of this act, be deprived of such premises by its landlord or a landlord.
Okay.
Again, it defines as on the commencement of this act. And then it's also a tenant who by virtue...
So you are a tenant, the time to pay rent is due, you are unable to pay the rent.
Yeah.
Then you continue to live on the premises because you can't afford to pay the rent. This, you are allowed to stay on as a statutory tenant and pay as and when.
No,
you cannot be evicted unless by an order of the rent magistrate.
No, a statutory tenant is a tenant who has been determined by a rent control officer or a magistrate.
Okay.
All the provisions, all the contradictions, if you go through as a statutory tenant, the law will catch up to you. The law states that whether you are a statutory tenant or a normal tenant, you are no right to owe any landlord more than a month's
I
rent.
wanted us to get it this way. I have a tenancy. The tenancy agreement, my period has expired.
Yes.
But I am not able to pay to continue.
Yes.
So the law talks about the irrevocability of my status in the premises.
Okay.
And you cannot remove me unless by an order of the rent magistrate.
Okay.
Right.
Yes, exactly.
All right.
And then again, we talked about section 17, subsection 5.
All right.
Where after the remodel or the construction of the place,
right,
you are to be considered first.
Right.
On that premises.
Thank you so very much. Emmanuel Hove Posu is the PRO or the Public Relations Officer of the Rent Control Department. This has been the second time he's joined us on the law. This has been the law. It's your legal light and it is your health law. We are very grateful. Thank you so very much. All right. Have a good afternoon. Join us next week.